Welcome, everybody. I will do this obviously in English. I have been in the United States for 37 years. My name is Cigdem. I went to college here, and I had my master's degree in New York at the New School for Social Research, and I started in the real world working in a law firm and studied law at the same time as going to school. So I worked full-time and went to law school. And I graduated and got my law degree in 1992. And since then, I have worked in big law firms, and I have also set up my own law firm in 1998 in New York City. So I just wanted to give you a little bit of my background. The way we can, I would like to explain in bold strokes the immigration picture. Being where you are, you obviously know a lot of the issues until arriving, but I assume most of you are on F1 visas or even beyond. Basically, in your area, in where you find yourself, the F1 will, as you know, lead to practical training, which you apply for at the earliest 90 days before, 60 days after completion of the studies. And with the optional practical training program, you can take any employment available. You can even set up your own companies. And if you find no employment with the OPT, it's a beneficial thing to do because you would be employed. Self-employment is acceptable under the optional practical training program. For that, of course, a company would have to be established, and you would be working for that company. This is something that also is interesting. I recommend it as a strategy for people who seek out employment and they have not been able to find employment. And for example, they have family or relatives or people, friends in Turkey who would like to set up a business, or they're doing business already in the United States. I recommend, why not already set up a company? You have employment authorization, and you can facilitate this company's business operations in the United States. That's something to think about if there is some thought like that in Turkey, and there is a need like that. So under the new F1 rules that they have established, they would like you to be not unemployed for 3 months. So they want you to be hooked up to an employment relationship. And if you are unemployed, you will fall out of status and you will lose your employment authorization status. So that is critical that it is acceptable to have a volunteer employment as well, so that even if you don't get paid, that will be acceptable for the OPT purposes, and that you can, of course, work in an area that is related intimately to the area of studies that you've had. After the F1 OPT is over, and hopefully before then, if you have found an employment opportunity, and if the H-1B visa quota is not completed, because the H-1B is subject to quota, you then would be able to switch to the H-1B visa through an employment offer. There are 65,000 H-1B visas, and it needs to be applied for not before April 1st of the year, because that's the soonest 6 months before the start of the fiscal year, which is October 1st. So let's say that you found an employment and a company willing to sponsor you. The company applies for you, let's say, on April 1st, and the H-1B is approved. And so if this date of April 1st is within the OPT time frame, during the validity of the OPT, then your OPT is extended automatically. Let's say your OPT ends in August or July. So if an H-1 offer of employment has been given to you and an H-1 has been filed before the OPT extension, your OPT will be automatically extended until October 1st. So you will be continued to be able to be continually employed with a valid status. And come October 1st, you will be able to automatically switch over to the H-1B visa. The H-1B visa is a very, simplistically speaking, it requires an employer, an offer, and an offer of an employment in a field that the individual obviously has studied that is directly related to the area of studies. And this enables the employer to file. Now, of course, in the world of immigration, the Immigration Service is one of the most dysfunctional agencies of the U.S. government. I would put it next to the IRS, and obviously if things are not properly done, but also if everything is properly being done, the Immigration Service has the tendency of questioning cases that have no bearing on the real world. They will question why would some company would need the services of somebody with a bachelor's degree or graduate degree in business administration, for example. You have to explain that to the Immigration Service, that some high school graduate cannot do this job. They also tend to question cases where an employer is small, they have few employees, new, 19-employee company can be considered small by the immigration standards sometimes. Or sometimes you don't know why. You just get what is called a request for additional information. And that's the battle of wits with the Immigration Service. And we prepare huge rebuttals, and so it's a little bit of a game, a fighting game with them. And, if you're well prepared, you're tenacious, you will do it fine. California Immigration Service is notoriously horrible because the IT sector there is very strong, and the Immigration Service is very scrutinizing on IT companies, as well as petitions involving the computer sciences and technology. They have come to believe that they're job shops, especially in the computer area, that hire people and then farm them out and take advantage of the employees, and that's why they will question those cases. They go to the point of asking contracts of the companies with their with their clients, and to the point of showing that there is enough things to do for the employee when the person gets the H-1B visa. So it can get really nasty. So basically, this is the route that most people who graduate from U.S. colleges, advanced studies, this is the 50 people coming now. Okay. Hoş geldiniz. And so the H1 is usually the route that is followed, so I just wanted to let me talk about that. Then people can move on to other visa options that may usually a situation happens when somebody's coming directly from abroad and they are extremely well known in their field, their profession, and they have built a reputation. They have articles in the press. They have written articles, or articles have been written about them. They have gotten awards in their field, in their country, or in the United States, or anywhere else. They may have publications. They may have worked as a judge of the work of others. They may have invented. They have certain inventions, perhaps, patents. Anybody who is really going to the top of their field in their home country would tend to potentially be entitled for an O1 visa. It's called an extraordinary ability visa, and that also requires an employer or an agent, depending on the field. If you are in the film industry, you are an actor, those kinds of things, you would need an agent or an employer. And those cases are pretty interesting to put together. And knowing ahead of time that there is such an option and knowing the criteria of the O1, one can also start preparing ahead of time, as you are building your career and as you are employed somewhere where your work makes a difference. Then you want to get your name out there. You want to talk with your employer to, if you've co-written an article with your employer, get your name on the publication from as early as you can so that you can build this incredible portfolio that might come in handy down the road. Because you know, an H-1 visa is valid only for a total maximum period of 6 years. And should it be that you have not been able to pursue a green card, or a company has not been able to offer you a green card, or you've been too busy to think about it, all of a sudden, time goes very fast. So you might as well start thinking of building a portfolio, knowing the criteria of the O1 ahead of time, so that if need be, you will be able to switch gears and move on onto another visa category. Those people who would like to stay on further in the United States, and let's say that they have an employment offer and they have a good relationship with their employer, I would also suggest that you start negotiating with your employer sooner rather than later to negotiate whether they will go forward with a green card application for you, because it's an investment that they're doing in you. They have trained you, or they have benefited from your expertise. You've learned about the company, its products, its services, and it's in the best interest of everybody to start thinking about this soon, because again, it's a very time sensitive. It can take a long time, and the sooner you start and get the employer engaged in your future in that respect, it's in your interest to do so. I have a client right now. She is on her last 6 months, and she's come to me, and she has not thought about this. And whereas she's very successful, she's a fashion designer. She's got her own line with the company, line of clothing, and yet she has not thought about this. Now it's like everything now is in high speed, scrambling at the last minute. So we will process her green card application. Now, there are various ways of applying for the green card, and the one that goes through the Department of Labor is the one that does take a long time, and especially it takes a long time for those people who have a university degree only and no master's degree. And the job that is being supporting this green card application requires only a university degree. So in that case, that application can go upwards of 5 years through the Department of Labor, plus there would be a waiting period, because green card applications through in that category are huge waiting period. There are many applicants in that category. If you can make a case that, yes, you have a university degree, but you also have 5 years of increasingly more responsible experience, not with the employer itself, then university plus 5 years can become, under the law, equivalent to a master's degree. So then your application can run under the master's degree category, which then implies that this case will go 2 years, maybe, at the most 3 years. So it will go much faster that way. So that's something to think about. And obviously the experience that you would have would not be in any field. It would be in a field that is totally related to what would be required for this position that is being offered to you. There are other alternatives. If your experience has been gained with the employer itself, then the employer, let's say the 5 years experience, you've gained it with the employer, that experience can also be used to switch you from a university to a master's degree case by enabling the employer to offer you a position that is different than the position that you've done and you've gained 5 years before. And that position has to be at least 50% different in terms, substantially different in terms of quality of duties, the nature of the duties, that switches you from one to the other. And if we can determine that, then you can use the experience gained on the job. So how does this work? Here is a position. Its requirements have been identified and very seriously thought out in the beginning. And you just get the ball and you throw it. And that's what you go with. That's why it has to be very carefully thought out in the outset. What is the ball you're throwing? What is the job? What are the requirements? Because that's what's going to make the case to go from beginning to end. So what do we do with this? We go to the Department of Labor. The employer will apply for a prevailing wage determination and will ask what the wage should be. And the prevailing wage determination is determined. That's what the employer has to pay. Now, you don't want to also run a case with an employer whose financial standing is also not good, because the employer has to be able to show that they can pay you the salary that it's offering during the entire process, the time that it takes for them to apply for the green card. So if the time comes towards the end of the process that the employer cannot show and prove to the Immigration Service that they can pay you the salary that they have to, the whole case goes down in the garbage. So you want, and what I do is I always give a memo to the employer and employee in the beginning, and to get their accountant to check and look at the financials of the company to make sure that there will be no problem 3 years down the road, because that's when it would happen. So you want to make sure in the beginning. So what happens? The prevailing wage determination is done. The employer checks, okay, we can pay this salary going forward now or later, but we can document it, we can financially pay the salary. This, with the prevailing wage, what the employer starts doing is starts a recruitment campaign, basically, to see if they're available, qualified, and willing U.S. workers who can do this job. So they have to do a huge recruitment campaign. They have to run ads in the paper, online, whatever the industry allows. It could be radio ads, all kinds of possible ways that, you know, that shows a good faith recruitment effort by the employer. And the whole application results, if there are any applicants, for example, let's say they're U.S. applicants who apply for this job, they have to meet to the letter the requirements of the position, okay? They cannot be hired and be trained and then one day they will be available. No, they have to possess all the requirements at the time. And if they're Americans who qualify for the job, they could be interviewed. They should be interviewed to see that indeed they have the qualifications. An employer obviously has to cannot discriminate, and they have to have a good faith recruitment effort in this regard. So let's say that if there is, by the way, somebody who qualifies, that individual would have to be hired by the company, and you don't get the green card. So this is a very important part of the process. Let's say that no qualified applicant has been found. Then the Department of Labor issues what is called a labor certification that says there are no qualified willing Americans to do this job. And then you move on to the next level. The employer then will find a petition documenting that they can support the case, the employee, the salary, and the employee will document the application that they actually are the one who actually fulfilled the requirements of the job. And in this process, this is accepted, then the person goes to the final stage where they get their fingerprints, their medical exams, and so forth. And thankfully, there are no interviews, final interviews. In the past, I've been in this long enough to know, to been there, that there used to be interviews at the Immigration Service when the case was done. But in labor-based, employment-based cases, they have taken that out. They don't do that anymore. What they do is kind of a quality control. Once in a while, they will get a case to be interviewed for their own quality control purposes. So this is the normal route that people follow who, for example, have come to study here from abroad and they've moved on, gotten a job, and gotten an H-1B, and then moved on to the next green card process. This is a normal course that happens. There are other ways of getting the green card. The other ways are a little bit on, on more sophisticated people with more sophisticated positions and backgrounds. And these categories, for example, are much faster to get, but they're also very intensive in terms of preparation of the file. It has to be a real big, huge file. First level is called the Extraordinary Ability Aliens. Now you are top of the top, you're top of the field, and again, there's a huge list of criteria that you would have that kind of resembles the O1, but it has a higher standard, and that you have gotten perhaps awards. I mean, the top awards, the Oscars, the Pulitzer Prizes. And you can swim through an application with that kind of award. However, if you don't have top awards like that, you have a whole series of other criteria that you are you could fulfill, and those are, again, if you have gotten any articles published about you, if you have worked in prestigious organization and in positions of importance, and that you have impacted the organizations, and these can be documented through press articles. Again, your contributions to a particular field through patents and discoveries, that you have acted as a judge of the work of others. Think of the Cannes Film Festival. Well, that kind of concept. You can be an editor in a magazine where you actually sift through and select articles, for example. I mean, it could be many, many ways one can be a judge of the work of others, that one has to be creative in terms of thinking through how one can fulfill that requirement. And these applications are, again, very document intensive. They want to see also not just your publications, for example, citations about your work. So that can become a huge, interesting statistical expertise that you go and your first level article publisher and all the citations of the work that you've done, and where have these citations been made, and have they then resulted in other work being created, any research output, through your citations. So you have to create a, you have to really make the work of the immigration officers easy, basically, in terms of documenting your contributions to the field. Sometimes the nature of the work is such that your work cannot be published because it's very proprietary. Maybe it's a very government-related or super not public. There could be some areas of work that has this kind of output. So that should have to be also documented and can be documented. If there's some explanation to that effect, could be basically provided to explain why this kind of documentation cannot be provided. The nature of the, and also it is very important to submit letters of recommendation from people in support of this kind of application. And these letters of recommendation obviously have to come from from people who have an arm's length relationship to you. They're not your mother, and they're also not your professors at the university, because you want people who have access to your work and who are independent judgment. They can render independent judgment of your work as they analyze and state for the record what exactly your contributions to the field are. Sometimes, a person carries various hats. So you may want to seek out and discuss these people's backgrounds, what other hats. Let's say he's a professor, but he happens to be perhaps the editor of the communications journal, some pertinent journal in the field, for example. So that person could as well make a supporting a letter using that aspect of there. But they have to be able to state for the record that how they have come to be aware of your work and how they can assess its qualities. I had there was a case where I'd used, I remember this, it was very creative use of this concept of carrying different hats. As it was a very important person in Turkey, and he was, this was a case of a Iranian origin Turkish citizen artist. And it was very prominent in Turkey. And the letter writer had written this letter on a station. I don't remember the name of the organization, but it was just after September 11 area, so that where everybody is very, very, concerned. And oh my God, the Middle East, Muslims. So, and he had this letterhead that had a sword, kalich, sword, from the letterhead had a sword coming from left, right, and then you had the Arabic script under the sword. I said, we cannot use this hat. And thankfully, he had many other good letterheads and organizations that he was. So this kind of thinking is very important because, and this goes with time. I mean, you really, really have to be seriously engaged in the case in that sort of way. So the letters of support and recommendation are also very, very important in supporting the case. And of course, the Immigration Service officers, I mean, they really don't know a lot of the things that you write about. And of course, with new staff hirings, they sometimes you wonder, some people are very interested in the arts, they may hire retired people. I mean, it's a big question, what kind of people actually work for the Immigration Service to review these kinds of cases, because you can imagine what kind of cases they can get. They are famous people from all around the world, from any kind of subject matter, subject area. There's a colleague of mine, he had a story that he had a case about this Tibetan monk, and his green card was somebody pretty renowned, and he had a letter of support from a representative, the highest body that reported in the country that the Immigration Service did not accept. And he responded basically saying that, well, shall we submit a letter from Her Highness the Queen, who was a former English, protectorate kind of thing. And of course, the letter was written by a high enough person that should have been acceptable. But then he had the guts of basically responding with simply one sentence, and that case was quickly approved. So you have to also know when to show your muscles with the Immigration Service, and when you have a case on your side, you also have to know when not to ruffle their feathers too much. So it's a very balanced, respect game, but also you are you're fighting for your client, and you have to show some activism, in the support of your case. So the extraordinary is not something that is a hard standard to meet. There's another area where one can use, and that is called an exceptional ability aliens, as well as the advanced degree professionals, higher level, higher than university, and in the national interest of the United States. So that has that can be also an interesting way to defend the case. And basically, you have to prove a certain sets of criteria that have been set in a case, New York transportation case, and you have to prove that the field in question is of an intrinsic interest to the United States. Okay, so cancer research, nuclear energy, you would have to, so that has to be first documented and supported and prove it. And then you have to be able to show that the interest is of nationwide import. So it's not something that impacts only New York area, for example. It has to be nationwide. If your documentation include things that say that certain areas of the United States, because of the nature of what it is, for example, the field is, then you would lose your case. And the third prong that you need to fulfill is that, sorry, that you getting the green card without doing a labor recruitment campaign that we've talked about before, which serves in protecting the interest of U.S. workers, which also is a national interest. That interest of protecting U.S. laborers is overcome by a higher interest in this case. That would be that if the company was required to conduct this campaign, they would not be able to identify and find a person that would fulfill this interest in the same equal way as this person would. So you have to show, be able to document that this person will put to the table a lot more strengths and input than a similarly qualified and educated U.S. worker. So that is a pretty hard thing to prove. And of course, all of this is through the documentation, the types of documentation we've talked about before. And again, with the letters of recommendation from third parties. It's not so much how many letters that are written also, is the quality and the credibility of the actual people who are writing. You could have letters from people who, we've had a case where this man was advanced mathematician, statistician, and he was using advanced modeling through this way, analyzing areas of military strife, for example, in Afghanistan, in Iraq, all those areas where there was huge problems. And they were analyzing the social networks in the areas where there was strife, and analyzing through mathematical means, how to deal with these things. And obviously these are very much of interest to the U.S. government and military and so forth. So the companies that were interested in this kind of work and the government agencies, so it was critical that he had the right support from those institutions to support his case. So this is kind of one way one can look at the immigration situation from university onward to the green card. There are other ways people come to this country, and I would like to talk a little bit about that. It may or may not involve you, but it may involve some of the people that you know, or but it's an interesting thing to know as well. And that is, if, for example, you have a company abroad, let's say you have a company in Turkey that's been doing business in more than a year and is successful, hires employees, has a staff, makes money, and that company wants to set up a subsidiary in the United States, wants to set up an office and wants to start business, doing trade, selling, consulting, whatever it is that the company wants to do. Then what is the way we will bring the people from that parent company to the United States? So what we do is we set up a U.S. company, which becomes an affiliated subsidiary of the Turkish company. And any key officers, executive managers, and specialized personnel of the Turkish company can then be transferred to the United States. There are various kinds of visas that can be used. There's the L1 visa. It's called the intra-company visa. And that visa requires that the individual have worked in a Turkish parent company for more than a year in an executive, managerial, or specialized knowledge capacity, and that the person will also work in such a capacity in the United States when transferred. Now, and the Turkish company must continue its operations during this whole process. In other words, after the person has come to the United States in the L1 status, they have to continue, the Turkish company must continue its operations for the individual to continue to be valid L1 status person in the United States. And when the United States company becomes financially healthy, employs American workers, and grows, so whenever that point is reached, then the company can apply for the individual for the green card, and would not have to go through the Department of Labor process of applying through the Department of Labor, recruitment, and so forth. This goes directly to the Immigration Service. And now, of course, the Immigration Service is no friendly place, that they will ask you a million questions potentially about whether your services are needed indeed for a full-time permanent basis. So that's why it is critical that the company activities, operations have reached a great point that you can show your company structure and that your company has created employment opportunities and is showing through its corporate tax returns that it's been a good corporate citizen, and then the case would be approved. So there is no rush in doing that. And I had a client they were from Kazakhstan, and they really were dying for doing it right away. And I counseled, no, just take the time, right? And they wanted to, they did it, and then it got denied. And so there was no harm in it, but they had to wait another period of time before their operations became stronger. So we reapplied again, and we got it through. So the L1 would be one way of transferring these individuals. Because the company is only 1 year in that period of time, 1 year old, the Immigration Service would only grant the L1 for 1 year, and then you would do these extensions every 2 years for a total of 7 years for executive managers. I hate to go and begging for an L1 visa for the Immigration Service generally, because they only give it to you for 1 year if it's a new company in the U.S. So I usually go and recommend my clients to apply for the investor visa, because usually in this kind of situation, an investment is effectuated in the United States company. And so investment means financial commitment. So U.S. company, Turkish company would have to wire funds to the U.S. company, sufficient enough to document the financial health and the commercial health of the business operations. And they have to prepare a business plan, and they have to document what exactly is the theme, the concept of this enterprise that they are putting together, and why it will succeed. Are there any competitors? Are there any business of similar nature out there that would compete? That has to be acknowledged, and it has to be proven wrong why your company and your products will be successful in the US market. And this visa, the investor visa, requires that the investment also is of a sufficient magnitude that it will not be a marginal company that just is barely making you, the owner, and your spouse and family to survive. So you have to show that, document that your company will be able to create employment opportunities for US workers. And that will have to be realistically plugged into your business plan. You would have to show exactly what during your 5 future years, how your employment strategy will be in the way of benefiting US workers. And the money that will be made in this company will not go to the support and survival of your family, basically. So this visa is the one that I normally recommend under this scenario because it is valid for 5 years. And because you do not go through with the immigration service, you don't go begging with the immigration service. And this application, we prepared, we put it together after helping the company being set up here in the US. And of course, lease agreement, there has to be a lease agreement, there has to be office space. It doesn't have to be a huge big lease, but it has to, it can be in a suite, office suite. And this whole application package is prepared, and we give it to our clients, and they then go and apply for the E2 visa at the United States consulate in Istanbul or Ankara, depending on where they reside. And so this application is directly reviewed and approved basically by the State Department. By law also it is like that, and they will then review very carefully your business plan. They will look at everything you put together as to, is it realistic? Is this viable? Is this company going to survive? Because it is valid for 5 years, the consular officials have to really believe that that this will be successful, so that for them to be able to give you the 5 full maximum period. In one scenario, one time, I had a client who was doing he was selling curtains, textiles, and that you could tell already that the consulate will be very scrutinizing this thing, because it was a huge area of competition. It would be importing curtains from Turkey, and sure enough, the consulate gave him only for 1 year, and they said, okay, you go, you show yourself, you see how you succeed, and then you come back to us and we will give you the full 5 years. So that's exactly what happened. But normally, if you have a good, well-prepared case, that the consular officials will have to be proud of opening you the doors to this country and saying, welcome, and come and bring your know-how, your capital in helping create jobs to the US workers. I've had situations where I know my clients, I always talk to my clients after their interview what happened. First of all, I get a call, good news, and then I want to hear what happened at the interview. What questions were asked, what was answered, and I am a bit of a slave driver with my clients, I have to admit, because I want them super well prepared, not just to get the visa, because they have to do a business plan. to get this visa. But that also teaches you to really look at your company, at your business. What is it that you want to do in a clear forward manner, straightforward manner, so you can see for yourself what it is that are the pluses, there are minuses, what are the risks, what's the competition, what's the prices. That's what you have to do anyway. So if you are, okay, a successful businessman from Turkey, but you've never had to do something like that or think like this in a rational sort of way, you have to have your hand held and prepared in this way. And so when you go to the consulate and face the U.S. consular officials, and you are proud, you know what your case entails. And I've had situations where the U.S. consular officials, for example, have said that they wanted to talk further about the business plan with the person, that they were so excited to see what they were planning to do. And guess what? I'm sure that the U.S. consular officials, they also get to get a sense from what's happening from Turkey into the United States by looking as to what it is that these companies are trying to accomplish. I've seen horrible cases prepared when things have gone out of whack, and a client has come to me to save them from the circumstances. I've had a case where a guy was, you know how Turkish people can get so sentimental and get so personal and get upset like the whole United States is against that person. There is no such thing. This person is taking very personally. I said, relax. You know, it's just the way this is presented. The consular officials have to, you know, we have to make their job easier so that when they look at this case, they have to understand A to Z, flip through it, and without having to understand what's exactly all this about. Imagine the role of the U.S. Consular officials is very hard to, you know, I mean, they can't just like simply throw away the case. It seems like that sometimes to people whose cases are dead, but they have to make sense. They have to be able to figure out why they're throwing out. They have to give an explanation as to why a case has been denied. Now, a denial of an E2 visa, investor visa, the chances are very slim. Why? How? Why would a consular official deny an E2 visa? That there was not enough sufficient investment amount. Okay, well, they will tell you, just go and invest some more. So you would know that would be a very easily, or arguments could be made perhaps that this is a sufficient investment. I had an investment from Belgian restaurant owners that they established 9 years ago. And the two immigrants, he's a Turkish immigrant family set up in Belgium, grew up there with his Albanian origin friend, also grew up in Belgium. They together opened a Belgian restaurant in Connecticut. And it was just really, they're childhood friends. And he invested something like, you know, $75,000 at the time. Now, I don't recommend that amount these days to, you know, because it's not enough to turn a business. But they are so successful that they are like, they opened 2 more, they're going to open another one. And for my end, you know, in terms of the pleasure that I get in the work that I do, is to see this succeed. Is just like you go back in your relationship for so long. A corporation established these people, and you see their growth, and you are part of their growth mechanism in this process. So it is very important. The amount of the investment, you know, these days are obviously you have to be realistic, and also is where. I mean, in New York versus, you know, in the middle of, I don't know, Tennessee, you know, different amounts would play. But they want you to take a risk, you know, in this process. You cannot get an investor visa without taking a risk. You cannot invest, for example, the proceeds of a loan. You cannot get a loan from the bank and invest that. That's the risk that the bank is taking, not you. Unless you put your house on a collateral, then the money, okay, you would be putting something at risk. I've had situations. In one situation, there was a restaurant worker, chef actually, who was applying, and they wanted to see the source of the money. Of course, you have to show that too. As part of your application, you have to know, you have to be able to show that this didn't come from drug trade or some mafia operation or slave trade. I mean, this money is clean money. Taxes have been paid on it in Turkey, and so you have to be able to document, the source of where the money is coming from. So in that case, for example, they asked, "Where's this money coming? How you working chef in a restaurant? Could put together this money?" He didn't want to pursue it. I mean, we could have, if he could have documented, if he wanted to document how he got it. So one of the reasons that, this case could be denied is the source of the money, clean money, what it is. Second is it enough? Can this business run sufficiently with this, successfully with this amount that will make other people, create jobs for other people and not just for the investor and his family? And also, have you robbed a bank yourself? What do you have in your criminal record? Do you have any problems in the past? Sometimes people like to forget certain things that have happened to them, and they make a big deal out of it, and they forget to tell the attorney in the beginning that actually there's a problem, because they don't want to think about it. And this could be deadly at the end of the process. I had a situation where, somebody was doing this thing, and he had an accident, and somebody died. It was a car accident. So in that situation, we have to go and analyze. There are different, the area of intersection between criminal law and immigration law is like the Bermuda Triangle. You have to really have a lawyer that is very, very well, experienced in this combination. And I will work in that case with another colleague of mine, and we analyze to see whether the foreign law under which the person was charged, is it comparable to a federal law in the United States that would constitute a crime of moral turpitude, which then makes the person excludable. So if not, then we will then say, okay, here we will prepare a memorandum of law, and the individual will be forthright about when they go to with this package of application. This will be as part of the application. We're not trying to hide anything. We're being upfront about it so we can deal with it. Because if the person doesn't disclose it, then what happens is, then they become excludable on another ground, which is willful misrepresentation and fraud, which then they become excludable forever from the United States. They can't even get a green card in the future, even if they were married to an American. So the consequences are quite serious. So you want to really take it face on, up front, and deal with that. So besides the E2 visa, as we said, the investor visa requires somebody to invest and then to get on with the business. Then there is another methodology, which is called a treaty trader visa. That one requires that there be already some exchange of trade between U.S. company and Turkish company, or United States company and Turkey, and that this trade be substantial. And of course, for that to happen, there has to be somebody right on site in the United States that has the right to work and who has been able to run these operations of the company, so that you, the owner, Turkish national, can come to the United States and run the business operations. And you would have to prove that with the documentation that you have actually had this company doing substantial trade. Now, substantial trade doesn't mean $1 million one time, but it could mean $100,000, 8 months, or something like that, so that there shows a pattern, a trend, that this is something that is happening, continuous and regular, and it goes on, and it will result in a successful continuation. I've had situations where my very impatient clients would like to do things a little faster, a little too fast for their own good and come to the United States as a visitor for business, and then set up this company and, oh, well, let me try to get this visitor for, come here as a visitor for business, and then see if, apply for the E1, treaty trader. Very bad idea, because then the question becomes, who has been running this trade between the United States and Turkey through the US company? You as a visitor for business, which is impossible because that visa category does not allow you to do this activity. A visitor for business cannot work in the United States, cannot render service for a US entity, can only come to the United States on behalf of a foreign entity, a foreign company, as their employee, to engage in negotiations and business and consult with business colleagues. So that person will have a serious problem when they prepare a package and go and apply for an E1 visa at the United States consulate. So that's something that you have to look for. What's the time? Oh, Tom zamanı. I was like, I can't even speak anymore.
You just touched with the higher education, like a master or PhD degree, but you haven't got details. Since there are some master students or PhD students or higher degree with a PhD, can you actually briefly mention about that opportunities which will be also helpful for us?
Well, the people who have masters and PhDs, what exactly are you concerned about? Are you interested in to learn? Well, we talked about the F1 options there. I don't know if you want to know something specifically about the F1, but the J1, for example, it's a visa that I hate. That's why I don't talk about it. And I'm sure once you get to know the visa, you hate it yourself. Because it's a visa that if you get money from the US government, let's say Fulbright, let's say your own Turkish government, then what happens is, they pay for it, for your education. And so how do you get out of this relationship and you want to continue getting another work visa and you want to get the green card? Well, you got a problem. If the Turkish government is paid, you have to get into some sort of arrangement with them that enables you to pay them little by little, and so that they can, I think they have changed their system somewhat, because I know somebody he used to be in Colombia, and he is now in Florida. I was told by somebody who knows intelligence. His name is Ahmet Pamuk, and they put together a group and they sued basically the Turkish government, because the Turkish government was taking a serious, hefty money, interest rates in this payback situation, way more than what a bank would charge. So, and I think they won, that the Turkish government is somewhat more lenient in terms of this payback, because if the Turkish government does not do a what is called a no objection letter, then you cannot waive the J1, 2-year foreign residency requirement. So that's why we don't like the J1 too much. 2-year foreign residency requirement means that you have to go back to Turkey and work there and then come back with another H1, with another L1, and so forth. Now, if this 2-year waiver cannot be obtained, okay, and you have an employment opportunity of a different kind, let's say that we can bypass the H1 route, for example, because the H1, in order to pass through the H1, you have to get the waiver. Now, if you cannot get the waiver because of the money relationship situation, maybe you can be eligible for an O1, okay? Now, O1 visa, the extraordinary ability visa we talked about, does not implicate the 2-year foreign residency rule. So if you have this opportunity, you want to take this opportunity, well, you have to be able to meet the criteria of the O1 so that you can switch from from the J1 to the O1. And that's why we talked earlier, it would be good for you to know the O1 criteria sooner rather than later so you can ease toward that. So while you are in the J1, you're doing what you're doing. Let's get you to start planning for your portfolio, O1 portfolio, so that when the time comes for that, you will have a nice package that you can do that. Same thing with the green card. You cannot go from the J1 to the green card unless you've either fulfilled your 2-year foreign residency requirement or you've gotten the Turkish government waiver of the 2-year foreign residency requirement.